Okay, ma. Okay, okay. Without PPT, you are presenting. Okay, good.
Yes, sir. Yes, sir. Good morning, sir. Good morning, everyone. Myself, Madhushri RK, studying BBA LLB in KSLU Law School. My topic is about live-in relationship, and I'm going to explain about Khushboo versus Kanniammal case, which is related to premarital sex, and it also covers the topic of right to speech and expression of a woman in country. We know, yes, Khushboo, she is a famous actress of India. She stated a statement for a Indian magazine, which created a controversy throughout the country. Raising voice for or against live-in relationship or premarital sex in India is always like twisting the knife. Premarital sex has faced a heated disagreement in this country for being the topic of obscenity. It have been a tug of war between the Indian culture and the right to live and liberty of a woman. The following case is one of the important cases because it deals with the protection of the fundamental rights of women and right to speech, right to expression, and it also gives us a criteria to check the obscenity of the statement given by any citizen of the country. The Honorable Supreme Court stated that the the obscenity is computed with respect to the current community standards that reflects the sensibility and tolerance of the reasonable average person of the country. Uh, Let us Nandita explain the what is premarital sex and live-in relationship. Though I want to give a conceptual analysis of premarital sex. Premarital sex is a sexual activity practiced by a person who is unmarried. Premarital sex is may take place in many number of situations. It may take place as a casual sex with at least one partner seeking to experience sex, and it may take place between the couple living together from for a long term relationship, and it can be engaged between the couple who are betrothed couple who are ready to get married, and many other situations. The prevalence of premarital sex has been increased in both developed and developing countries. Like in the countries like our India, the premarital sex is directly linked to the concept of virginity. Social aspects to premarital sex has been changed in various society, but in India it is like the dust thrown to the holy ritual called marriage. A, uh, a three-judge bench of Chief Justice Dr. K.G. Balakrishna, Deepak Verma, and B.S. Chauhan observed and asked the people that please tell us what is the offense and under which section is the premarital sex offense. And also stated that a living relationship is right to life. The apex court said, apparently referring to Article 21, which guaranteed right to life and liberty, a fundamental right. Like every time, whenever the topic of premarital sex or live-in relationship arises, the court refers to the Article 21, and it gives people, and it gives the people. It gives the people what live-in relation. It gives the people the information that live-in relationship comes under Article 21, and it is not live-in relationship is not legalized in our country. Sometimes live-in relationship leaves out some harmful effects to the participant. One participant or both who are in the live-in relationship, such as unwanted pregnancy, teenage pregnancy, abortion, STDs like sexual transmitted diseases like HIV, AIDS, and regrets, guilt, loss of self-respect, depression, loss of family support, substance abuse, and sometimes it may lead to the suicidal death also. So let us let us discuss about the case. Yes, Khushboo versus Kanniammal. And let us check through the facts and background of the case. Hereinafter, yes, Khushboo, the famous actress, is referred as the appellant. Appellant is one who appeals the court. So, yes, Khushboo is appellant in this case, and the respondent is Kanniammal. This case was decided on 28th April 2010. Bench. It was a three-judge bench with Honorable Justice Dr. B.S. Chauhan, Honorable Justice K.G. Balakrishnan, Honorable Justice Deepak Verma. Let us discuss the facts related to the case. Yes, Khushboo, hereinafter referred as the appellant, who is a well-known actress, has approached the Honorable Supreme Court to seek quashing of criminal proceedings pending against her. 23 criminal proceedings were filed against her, and hereinafter referred respondent Kanniammal filed these cases on her. Apparently, mostly in the case of Tamil Nadu, for the offences, the cases were filed against her for the offences committed under the sections 499, 500, and 505 of the Indian Penal Code, uh, 18, 1860, and sections 4 and 6 of the Indecent Representation of Women Prohibition Act 1986. The trigger of these offences was some remark made by the appellant regarding the topic, which was increasing incidence of which the premarital sex is the increasing incidence nowadays in our country. In that context of live-in relationship, to a yes, Khushboo gave us to a leading news magazine, that is India Today, and later on the same issue was reported in the local magazine, local periodical named Dinatanti. The appellant, who faced difficulties by contesting the criminal proceedings in the different locations, she the appellant had approached the High Court of Madras, praying for the quashing of these proceedings through the exercise of inherent power of the High Court, but the High Court rejected her plea. At the same time, in order to prevent the inconvenience by litigating many cases in different locations, she directed that all the cases instituted against her, the appellant, be consolidated and tried together by Chief Metropolitan Magistrate Egmore of Chennai. Aggrieved by the aforesaid judgment, the appellant approached the Supreme Court by the way of batch of special leave petition. And now I want to state the actual statement made by the appellant. Let us check out, is there any mistakes in her statement, or is she right in her statement? She stated, like, according to me, sex is not only concerned with the body, but also concerned with the conscience. I could not understand matters such as changing boyfriends every week. When a girl is committed to be to her boyfriend, she can tell her parents and go out with him. When their daughter is having a serious relationship, the parents should allow the same. Our society should come out of thinking that at the time of marriage, the girls should be with virginity. But when having sexual relationship, the girls should protect themselves from conceiving and getting venereal diseases. This was the statement made by S. Khushboo, madam, which educated the Indian girls about the sexually transmitted diseases and created awareness. The issue was raised whether the appellant's remarks could respond reasonably amount to offense of
You muted.
defamation as defined under.
Go on, Namadush. Now, okay.
Yes, sir. whether the appellant's remark could reasonably amount to offense of defamation as defined under Section 499 of Indian Penal Code 1860. The contentions were raised from both the appellant's side and the respondent side. The contentions were as followed. The learned senior counsel appearing for the appellant has submitted that the respondents were not the persons aggrieved within the meaning of Section 199 of Criminal Procedure Code, and hence they were not competent to institute private complaints. Whereas the Section 199 tells that the woman cannot be represented. She is not compulsorily. She cannot represent in the court. She can represent herself by the lawyers, advocates. Next, the learned senior counsel said that appellant had made a fair and responsible comment as a prudent person, and therefore the opinion expressed by the appellant is fully protected under Article 19(1)(a) of the Constitution of India, which the senior counsel refers that her statement is protected under the right to speech and right to expression of the appellant. Further, it was contended that even if the allegation in the various complaints are taken on their face value, the same did not disclose any offense neither according to the different sections of IPC nor the sections of Indecent Representation of Women Prohibition Act 1986. The respondents also raised their contentions. The learned senior counsel appearing for the respondent side has submitted, since the High Court has refused the appeal by the appellant, yes, Khushboo. The senior counsels also refers to the court that the honorable court should not interfere in this matter, because the complaints require determination of the factual controversies that are best left to the declared by the court of first instance. And further, it was submitted that the appellant's constitutional protection for speech and expression is not absolute, and that it is the subject to reasonable restrictions based on the consideration of public order, defamation, and decency and morality, among other grounds. The court also made some observations regarding to this case. The observation made by the Supreme Court are as follows: that the Supreme Court observed that the appellant has merely referred to the increasing instance of the premarital sex in the country and called for its acceptance of the survey. At no point of time the appellant described the sexual act, or she didn't said anything which may cause or arise some sexual desires in the prudent readers. Thus, it becomes difficult to appreciate the claim that the statements published as part of the survey were in the nature of obscenity. The court also observed that with regard to complaints in question, there is neither any intent on the part of the appellant to cause any harm to the societal groups or any woman or any person, or she didn't cause any harm to the reputation of any citizen of the country. In short, both the harm to their reputation. The court stated that in order to establish the offense under Section 509 IPC, it is necessary to show that the modesty of a particular woman or a readily identifiable group of women has been inserted by a spoken word, gesture, or a physical activity. Clearly, this offense cannot be made out when the complaint's grievance is with the publication of what the appellant had in the written form. Likewise, Section 153A has no application to the present case, since the appellant was not speaking on behalf of one group, or the content of their statement did not directed against any community or any person. The court also the interesting point in this whole case is the court also noted that the most complaints are associated with the PMK, a political party of Tamil Nadu, which is active in Tamil Nadu, and hence adds the weight to fact that this complete 23 criminal proceedings and the FIRs, criminal cases were impugned complaints have been filed with the intention of gaining undue political mileage. So the Honorable Supreme Court of three-benched Dr. B.S. Chauhan, Deepak Verma, they gave a landmark judgment to this case. The judgment was the Supreme Court held there is no prima facie. Prima facie means the first impression from the based on the first impression, no case of defamation in the present case. The court also found the institution of numerous criminal complaints against the appellant has done in with the bad intentions, that is malafide manner, in order to prevent the abuse of the criminal law machinery. It would be appropriate to grant the relief sought by the appellant, that is to quash all the complaints. Finally, all the complaints, that is criminal proceedings against Khushboo, were quashed. In such cases, the proper course for magistrates is to use their statutory powers to direct an investigation into the allegation. Therefore, it is not the task of the criminal law to punish individuals merely for expressing their unpopular views. Let us go through some cases which are related to premarital sex, where the judgment was given for the premarital sex. In the Lata Singh, as Nandita referred, Lata Singh versus State of UP, and another 2006, where the court held that a major girl is free to marry anyone she likes or may live with anyone she likes. The court further held that no offense has been committed by the accused, and present is an abuse of the process of the court and the administration mechanism. And another case which I like to refer, because sir, you asked about the maintenance. Alok Kumar versus State 2010. The court held that in a live-in relationship, there are no strings attached, and such a relationship does not create any legal bond among the parties or the partners. The court, while referring to the live-in relationship as a walk-in and walk-out, held that these who do not wish to enter in such relations may enter in the bond of marriage, where the parties are not allowed to simply break the bond and have legal obligations too. Individuals who are in live-in relationships cannot complain of immorality, cannot complain about the immorality, since live-in relationship usually between unmarried couple. So I would like to conclude by saying that this judgment of the Supreme Court, the landmark judgment on Khushboo's case, is based upon a fact which the framers of the Constitution are also recognized, that it's they should look after the importance of safeguarding the freedom of speech and expression, since the free flow of opinions and ideas is essential to sustain the collective of the citizenry. Also, an informed citizenry is a precondition for meaningful governance, as it promotes the open dialogue between the government and the society.